Okay, today is July 9, 2013. This is a statement under oath for Workmen's Comp Settlement Conference in Stockton, California for Administrative Judge Grill hearing. I was hired in 2002. At that time, I bought a lifetime medical plan. I paid $2,000 to $3,000 plus, and I could retire anytime after 2 or 3 years. Okay, so anyway, this is all about a disability, hearing impairment, and I have a permanent disability according to the QME report. I took a QME report, a physical on October 1st, 2010. On October 2010, the doctor said he doesn't do hearing. And so at that time, the QME report wasn't complete, but yet he made out a QME report, and I received it on December 1st along with a notice of offer of work. Good for 1 year, which I asked for the 10 o'clock Eureka run in the morning, which I didn't start one day on. On the notice of offer of work was sent by Espinoza, Safeway Insurance, in Arizona, okay, claim adjuster. I received it on December 1st, 2010. On December 3rd, 2010, I went to work. On December 7th, 2010, they just sent me home. Nothing in writing, who, what, where, when, and why, nothing. And Safeway is a union shop. They're under a contract. They're supposed to work me first, grieve later. It didn't happen. I was supposed to have representation upon interrogation on December 7, 2010. It didn't happen. He told me to sit down, and a shop steward's on his way. I had a second interrogation by Mike Sadler, safety manager. He didn't have any statement from the dispatcher who made the false accusations. He just had a letter in his hand that he posted some time back, which I don't recall what it was about or anything else. I was just totally, I was surprised. I went to work and this guy came at me and I was just totally surprised. I didn't know what the heck was going on. So after the shop steward came, we went in to see Mike Sadler. And he had the posting in his hand. Statement wasn't even wrote up yet. He asked for my seniority. Shop steward said it's a safety issue and he's going to look into it. He asked for my security badge, and then he had the shop steward send me home. Didn't allow me to clock out or anything else. We have 2 time clocks. We have a trip sheet that belongs to the tractor. We're under Department of Transportation regulation. When we log out of that tractor, we're supposed to go home, according to the regulation, but we're not allowed to do so. We have to clock out in the driver's room, clock in and out. I should note for one thing that we bid every 6 months, automatic start every morning. I have to be there at 10:30. Automatic start, I'm already on duty at 10:30 in the morning. So in any event, the dispatcher on December 6, 2010, falsified my logs by changing the time, taking the time from the second time clock and changing the time on my logs. Now, why he did that, I don't know, but that's what he did. In doing so, he put me in violation of the Department of Transportation and company policy. And me, myself, and 400 other truck drivers follow company policy. You will follow Department of Transportation regulation. You will follow the DOT regulation, and that's what we all do. And we also have a no fault attendance policy that it's part of company policy that we've had for the last 10 or 20 years. So what his reason is, I don't know, and why he took the time off the second time clock, I have no idea. I haven't been paid by that second time clock in 10 years. There's no time card. If I run out of miles or hours, and I'm in Livermore or somewhere, I'm supposed to log out. According to the regulation, I'm supposed to go home. But that's not the case. They send a pickup truck and they pick me up, and then I drive back and clock out on the company time clock. And it's not being recorded. It's not being recorded. We only get paid by the trip miles. That's it. It doesn't show anything else on the log unless they alter it. They're not allowed to do so unless they make the driver aware in the remarks section what the problem is. What the problem is. It wasn't done. So any event on December 6th, that's what he did. On December 7th, 2010, to much of my surprise, I walked into something, and I have no idea what I walked into because I had no representation. He told me to sit down. The shop steward's on his way. At that time, I had a notice of offer of work that I received on December 1st, 2010. And then when I went to work on December 3rd, 2010, on the 5th day of work, when I was going to turn it in, I was sent home. So in any event, Mike said I was looking into it, and he sent me home, and I'm sitting here waiting for registered mail or a phone call due to the fact that I'm supposed to work first and grieve later. It didn't happen. And I didn't get anything in writing stating why or who or what. Whatever, nothing in writing, okay, not by registered mail or anything else, not even the Board of Adjustments. I should note that if no registered mail or nothing in writing is received within 10 days, the issues are dropped, null and void, final and binding. Issues are dropped. They didn't respond within 10 days to produce evidence or documents to show what my disciplinary action is. And on December 17th, the BA Mike Nicewanger, Mr. Nicewanger, sent James Williams, the transportation manager, a letter asking for him to set a date and time to have a panel hearing. And he set it for January 11, 2011. That's more than 30 days. In any event, long story short, they didn't accommodate me at any time. The panel hearing, they just sent me home, and I told them I had a severe, profound hearing impairment, and I asked them if they were an authority. There was no reply. Mr. Nicewanger was there, the BA from Local 439 in Stockton, California. They just flat out sent me home. I asked for arbitration from the union attorney, and I sent him a prescription and the test results for severe, profound hearing impairment. He ignored it. And he denied me arbitration, and he put it on workman's comp, stating in the letter that he's aware I have disability issues, and he laid it on workman's comp to resolve these issues. Now, why he did that, I don't know, but that's what he did, and that's what happened. And come to find out, Judge Grill had to order a report, a legal document for severe, profound hearing impairment. And I should note that I received a copy of that, and it states that I've had a hearing problem since 2006. I've had a hearing problem, and I haven't been accommodated all that time. So there are disability issues. The union is aware of the fact that I have disability issues. And there's no doubt about it, yet they didn't want to deal with the situation. They laid it on workman's comp to return me to work because I'm supposed to work first and grieve later. It didn't happen, and they didn't file within 10 days. They didn't produce any documents, so I should get all back pay and benefits, RSVP, lifetime medical, behind the notice of offer of work. I should note that there's over 400 truck drivers there, and we all work 14 hours a day, and that there's no time card on the second time clock. So there's no, I've never been paid in the last 10 years. So how the judge wants to handle this, I don't know. But in any event, I need a court order to get my back pay at 14 hours a day from December 7th. Until I'm returned to work, till they enforce a notice of offer of work. Due to the fact that Esperanza Safeway Insurance in Arizona sent me a notice of offer of work, like I said before, I received a second notice of offer of work from MORLES claim adjuster Phoenix, Arizona. Um, the attorney sent me a letter to report to work, and Mike Sadler says he doesn't know anything about it, and the union didn't take any action. So I'm sitting here waiting for a phone call or registered mail to be returned to work, and it didn't happen. So what the judge wants to do about that, I don't know. But the fact is that they didn't pay my health and welfare. They stopped paying my health and welfare and my lifetime medical plan, which is a premium. When I retire, which I could retire at any time, I don't pay any premium when I retire. I don't pay any payments. Okay? So I need that notice of offer of work and forced to be returned to work. I need that 1 year or longer if I can get it. But I need protection from the court, and I need a court order in order to get all back pay at 14 hours a day. Otherwise, it's not going to happen. So just one thing, I just want to clear up the fact that I went to the department, to the highway patrol office, and I took my logs there and had him look at it, and my wife was there. He said that it appears that my all logs were tampered or altered with. Tampered or altered with. And the dispatcher is the only one with a key to be able to do that. Okay? And he didn't make me aware on December 7th what he did. He just falsified my documents and put me in violation of company policy and DOT regulation. And I received a notice of offer of work on on December 1st, 2010, like I said, and on December 7th, 2010, he just flat out sent me home. He falsified my documents, and he didn't allow me representation. He told me to sit down. The sharpshooter's on his way. And then Mike Sadler asked for my seniority on the second interrogation, and the sharpshooter was there, and he said it was a safety issue, which was ignored, and he's going to look into it, and I haven't been notified since. I was sent home with nothing in writing, and no time limits were met, so it's null and void filing binding, and all issues are dropped. So I'm sitting here waiting for a phone call or registered mail to report to work according to the notice of offer of work. It hasn't been done. So, and I should note, that's two. Two claim adjusters sent me a notice of offer of work. And the attorney sent me a letter report, and like I said before, it wasn't honored. So, I'd just like the administrative Judge Gill to be aware of that, and the fact that the union should be held responsible because of my disability issues and a hearing impairment, and they didn't accommodate me at any time. And Safeway never produced any documents or anything in writing showing what my disciplinary matter is or what it was or anything else. And they didn't file within the time limits. And on December 17, 2010, Mike Sadler filed a grievance. It was received by Local 439 and Stockton, California Teamsters, a grievance, which was more than 10 days. And James Williams, the transportation manager, set a time and date for January 11, 2011. That's more than 30 days. And he was also asked to produce all evidence and documents by December 25th, 2010. It didn't happen. He didn't produce anything. So all issues are dropped, final and binding, null and void. There are no issues. So on December 7, 2010, he just sent me home after I received a notice of offer of work on December 1st, 2010. Now, going on from there, Adam Stewart didn't put on anything on Administrative Judge Grill's desk on the first settlement conference hearing. He didn't put the notice of offer of work on his desk. He didn't put the severe profound hearing impairment on his desk. Judge Gill had to order for the two attorneys to get a legal document, which they did, and he's probably has the legal document, which I have a copy, which states that I've had a hearing problem since 2006, and I haven't been accommodated. So again, the notice of offer of work needs to be enforced. If it at all possible, Judge Grill can take that into consideration, I would appreciate it.
Today is Sunday, March 3rd, 2013. Another notation for the record for court. The fact is, I took a QME report in October, and in the QME report, it states the fact that he doesn't do hearing tests, and the QME report wasn't complete, and that Adam Stewart didn't send me to a hearing doctor to have a hearing test, and the fact that he wrote down that I had a permanent disability and how much it was, and the fact that I filed that I had a hearing impairment in 2009, and when I went to settlement conference, nothing was on the table for Judge Grill. The QME report wasn't complete. The severe profound hearing impairment wasn't on his table. And the fact is that, like I said before, they just flat out sent me home, and the QME report wasn't finished. And I didn't do anything wrong. I'm innocent. And the fact that they called up and the Health and Welfare Department and said I didn't work there anymore was a mistake, because I paid for that lifetime medical, and I could have retired any time after 2003 or 4. I could have retired at any time and had lifetime medical with no premium. And I have a disability. In fact, I didn't realize how severe my hearing impairment was. So they need to honor the notice of offer of work. They knew I had a QME report that I had a permanent disability and that I was on FMLA, and the QME report wasn't complete. And they just flat out sent me home, and then said that I was fired on December 16, 2010, the union attorney, when in fact they didn't follow contractual procedures. And most important of all, they didn't notify me that I was suspended or fired or anything else. They just flat out sent me home. I can assume anything at that point, but I didn't, because I have 200 employees underneath me and I didn't do anything wrong, and I have a permanent disability. In fact, on top of that, when the QME report was complete, I should note that for the record, that I'm deaf. I have a hearing impairment. And according to the 2009 Disability Act, which I'm protected under by the federal government, for people with hearing impairment. So, and I don't know what the workman's comp rules are, or if the Disability Act applies in this situation. So that's why I'm requesting to go to trial. And I'm also requesting that Mr. or Mrs. MORLES replace my lifetime medical immediately by court order, for the fact that Safeway called up and I don't have no lifetime medical for myself or my family, or to cure or relieve pain and suffering from the on-the-job injury. So, and I'm guaranteed that 1 year, and I need that 1 year. So again, the reason for the notation is the fact that the QME report was not complete, and it states in the QME report that he doesn't do hearing tests. So Adam Stewart was required to send me to a hearing to get a legal document, which he didn't do, in October, when the QME stated and made a statement in the QME report the fact that he doesn't do hearing tests. So That's all I want to make a notation to the court, and I need to remember that to bring it up to Judge Brill in the settlement conference. A request for trial that the QME report was not complete, and it states in there that he doesn't do hearing tests. But the fact is, he did state I have a permanent disability, and I could do my job. Okay, so and the fact that when they were aware of this, they just flat out sent me home. There's no need to go into about the dispatcher or anything else. There's no doubt that that man is guilty. And there's no doubt that the fact that they had a no fault attendance policy for maybe 30 years, 40 years, who knows, but they've had it for such a long time, it's just unbelievable. No fault attendance policy. So, so I'm innocent. There's no doubt about the fact that I'm innocent. They sent me home because I have a disability.
And I'd like to note one thing, that on the second interrogation with Mike Sadler and the shop steward was there, the fact is that the dispatcher didn't even make a report out. He didn't even make a report out what my disciplinary matter is. Mike Sadler just assumed that I knew about the posting on the bulletin board. He made an assumption. There was no investigation. There wasn't anything. He just assumed that I knew about the posting, which I didn't. I told him, I don't know what you're talking about. And he asked for my seniority. Now, why he did that, I don't know. And I said it repeatedly. I don't know what you're talking about. I didn't falsify anything. But he assumed, he took it upon himself and assumed that I was guilty and took my security badge and had the shop steward send me home without no investigation or no evidence or anything else, and nothing in writing, and sent me home just like that with nothing in writing. Just sent me home and said I was going to look into it. Okay, and and according to the contract, he's supposed to work me first and grieve later. So it's wrong. What he did was wrong. He shouldn't have sent me home. He should have worked me first and grieve later. Okay? Again, I like the Administrative Judge Grill to realize the fact that there was no report made out by the dispatcher what my disciplinary matter is to be or what it is. He just made an assumption off the bulletin board and pronounced me guilty without having a hearing or representation whatsoever. So I'd like to note that to Administrative Judge Grill to take that into consideration.
And I have a hearing impairment. There's no doubt about that, because the QME report is now complete. And when I go to the settlement conference, when I get my court date, I'm going to make that statement under oath. And I'll have a notice of offer of work. I'll have a legal document that I'm deaf, that I have a hearing impairment, and that I should be returned to work according to the notice of offer of work that is supported by a QME report from October, and the fact that Adam Stewart didn't put all that on Judge Grill's desk, so I'm asking for enforcement of that notice of offer of work, and whatever I asked for in my other statement. But the point is, not to make a long story, a short story into a long story, which I'm rattling on, because I do have a profound hearing impairment, and it's really bad. It's really bad. My wife is irritated. I'm talking really loud, and it's just I need to be returned to work. I can do my job. I don't have a problem doing my job or going to work or anything else. I need that 1 year, and it's very important. I shouldn't be denied that 1 year, no matter what. So I'm going to ask Judge Grill if he could do that, and if the union was correct in sending me home and not accommodating me with a listening device at the panel hearing, when they just flat out sent me home and didn't finish the panel hearing. So that's why I need to go to trial. That issue and the fact that my lifetime medical insurance, that's also an issue needs to be resolved by the court, by Superior Court or the workman comp judge. I need to go to trial. Because it's not right. I informed the union that I had a severe profound hearing impairment, and they made the statement the fact that they were aware of it and I had disability issues. And the fact that they just flat out sent me home and didn't finish to complete the panel hearing, let alone produce any evidence why or why not did they send me home. They just flat out sent me home. Nothing in writing or that I was suspended or anything else. They just didn't do anything. And I don't even know why I'm sitting at home. Why am I sitting here? I don't have any documents that states why I'm not working. Not one but registered mail or time limits. Not one document explaining to me why I'm sitting here waiting for a phone call or registered mail to report to work. And it's going on 3 years. I don't have one document. Not one. So I should get paid. From December 7, 2010, there's no doubt about it. I should get paid. This is just nothing but harassment. And it could be retaliation. I don't know. That's why I need to go to trial. I need to find out why this is all happening. I wasn't informed by the time limits or any other thing. No registered mail, not one. You know, not even a Dear John letter, nothing. And I haven't been able to get treatment or anything else. And I've had to pay for my own a payment with my acupuncture, and I can't get her as an acupuncture for my treating physician because she's not. Her name is not on the HMO list. So I got to go to this other one, and I really don't want to because I've been treated by this other lady for so long. I don't want to start all over again. It's crazy. So I'm going to have to wait until I go to trial and try to, you know, get by. But I need to return to work. If I can just get to work and get my back pay, I can get my own organic medicine, whatever it is, and take care of myself until I get my lifetime medical. And then I can go in and get my pinched nerve fixed because I got medical insurance for life. And I'm being denied the right to get my disability fixed or cured or relieved from any stress or pain from the on-the-job injury because of their actions. And like I said before, I don't have one document of why I'm sitting here. Not one. I have no registered mail, not one, not one registered mail. Never mind with Neiswanger, he's not Safeway. He's the union. They don't have the right to say I'm fired or I'm being disciplined or anything else. Safeway needs to inform me of what's going on, not the union. And the union didn't do anything. I mean, I had to wait till 2011 to actually find out what the heck is going on because there was nothing showed to me or registered mail of what this was all about. That's insane. And I have a permanent disability. Nothing was put even on Judge Grill's desk. He don't even know what's going on. So, I don't know. I need to go to trial. And I need my lifetime medical returned immediately. That Safeway private insurance in Arizona needs to replace that lifetime medical. So I'm going to request that in court, that they return that lifetime medical because there's no reason why I should not be covered with lifetime medical that I paid for in 2003. And I could have retired any time after that. I could have retired. I'm qualified to retire now. But I need that 1 year. They offered it. It's an agreement. So I need to go to trial. because I'm being persecuted and I'm being sitting here and it's really hard. I'm a good worker. I didn't do anything wrong. You know, I just, it's just not fair. I'm dragging on with this notation again. I wish I could stop repeating myself over and over and over again. And they need to accommodate me with some hearing aids. I got to tell you, I bought the first pair, but they're not right. They don't block out background noise or static or this or that, you know. And I got to also remind myself on December 7, 2010, that dispatcher, he was loud. I don't know what he said, but he was loud. I had to step back because he was waving his hands and this, and all this. I didn't know what the hell he was talking about. I mean, the guy was just frantic. I mean, Jesus Christ, man! I really walked into it on that day, and I did my work. I didn't do anything wrong. You know, I mean, there was no need for all of that, raising your hands and just bragging to everybody how I got Julio's. Got what? I got nothing in writing, nothing stating why this or that or anything else. So I was falsely accused of whatever it is. I was falsely accused. I know I found out something in January 2011 when they set the panel date, which they shouldn't have. I should have went to Board of Adjustments. But even then, what was I going to Board of Adjustments for? I don't even know. I don't even know what the disciplinary matter really is, because I was never notified and they never produced one document of what the disciplinary action was about. Not one. And the fact that they didn't meet the time limits like they do for 1,500 other teamsters and put them back to work, there was no reason why they shouldn't put me back to work. And James Williams, the transportation manager, it falls on his lap because he's responsible. He's the oversight for Mike Sadler and the rest of the transportation department. So I'm not going to make any accusations in that respect, because I'm going to let the judge do it. Let him decide what's correct, and let him tell me why was I sent home on December 7, 2010. I received a notice of offer on December 1st, okay? On the 3rd, I went to work. On the 5th day of work, he just flat out sent me home. And the rest is history. And the QME report wasn't finished yet, but yet they offered me a year worth of work, and the QME report wasn't even finished. It wasn't complete. So, I don't know. I'm looking into this thing for going on 3 years, trying to figure out, because I'm innocent. I'm fighting back. And I just don't get it, man. I don't feel guilt ridden. I don't feel guilty about anything. I just don't get it, and I can't figure out why they shouldn't pay me back pay. I'd sure like to know why they shouldn't. They didn't notify me of anything. They have no excuse why not. And even though I can't get employment because of the said actions of the dispatcher and their said actions, it still wouldn't matter anyway, because I didn't do anything wrong. I have to sit here and wait to be called for work. It's true. Because if I'm not available when they call or call back, when they call me for work, they can fire me. So I wasn't notified. I was sent home. I got to sit here and wait. I wasn't notified. The QME report wasn't finished. They knew I had a permanent disability and a hearing problem. They knew all of the above. And I knew nothing of the below. So now I'm sitting here waiting to go to trial. And I got to tell Judge Bill I need to go to trial. This needs to be heard in trial and find out if they're guilty or not. And I need my lifetime medical and notice of offer of work to be enforced, and I'm to be allowed to report to work one way or the other because they don't comply. They don't comply, obviously. 3 times they didn't comply. They didn't comply with the contract. They didn't follow contractual procedures. They didn't follow the administrative judge suggestion. And I have a witness to that. And they didn't comply when the union attorney sent me to work. They didn't comply then either. And I guess they're not complying with the private insurance company Safeway in Arizona. So that could be 4 times. They're just not complying. The insurance company is telling my attorney, okay, I see the company offered you work for 1 year. Okay, go ahead and send this guy to work. Well, so what's going on? Well, I'm not working. Why wasn't I working then? Well, they shouldn't have sent me home. They should have completed the QME report before they sent me home. Okay, so they don't complete the QME report. They send me home, and then on the 16th, the union attorney, with no evidence, nothing whatsoever in his hand, and knowing about the fact that I have a hearing impairment,
and the fact that they're supposed to work me first and grieve later, and the union attorney didn't even mention that fact. They're supposed to work me first and grieve later. I should have been working all this time, but I wasn't working.
Decides not to follow contractual procedures with no evidence. Not one point can he state why I'm staying home, and I was notified according to contractual procedures. Now, I'm not accusing the attorney of not following his own contract or arrangement with local 439. I'm going to let the judge do that. Really something, huh? An attorney. A lot to be said about that in court. So I guess we'll find out when we have discovery. And I don't know. My kid's life is at risk. My wife is sick, and I'm going through all this. And there's nothing in writing. I received nothing in writing of why. But I have to sit here and wait for a phone call or registered mail to report to work. And why, not one good reason why that I lost my lifetime medical that I paid for or contribute to. I paid 5 years ahead. They called up Health and Welfare because I called them and they said, no, you don't work there anymore. So I lost it. They need to replace it. Safeway private insurance company needs to replace my lifetime medical insurance. For the fact that on December 7, 2010, or in October when they made the QME report and the doctor says I don't do hearing, the QME report was not complete at that point. And the fact that they took it upon themselves to send me home with a permanent disability and the QME report not being complete, and the union attorney not allowing me to go to arbitration or finish the panel hearing regarding the QME report not being complete, or having me sent to a hearing specialist to find out if I'm telling the truth, he got the cart before the horse. And not even the union attorney can produce anything that why I was sent home. It's just the garbage. It's useless. The statements are useless. They have nothing to back it up with because they didn't send it within the time limits. So their statements or anything that they say is null and void. So they don't have any grounds. Because according to state law, my assumption is they have to give me something in writing or let me know why they sent me home. They got to tell me something. They got to notify me. I don't see anything in the law that says they can take my lifetime medical away and just flat out send me home and accuse me of making false accusations that they can't back up. Did an injustice occur? I'm sure it did. So we're going to find out in discovery exactly why am I sitting here? And is it proper? Okay? I should get all my money back. And my money back and plus whatever the Disability Act calls for. So, I'm asking for trial, and I need to note this and make sure I bring it up to Judge Grill, the fact that Adam Stewart didn't put anything on the table. The fact that I wasn't notified at any time, place, or anything else of why I was sent home. Nothing in writing. In fact, when they sent the letter to me from the union attorney to my attorney that I was discharged on December 16, 2010, they didn't state why. Didn't make one statement on why or any evidence or the fact that I was handed something in writing according to the contract when they sent me home of why I was being sent home and required to go to Board of Adjustments within 30 days of time of incident. No documents to show why I was sent home within the time limits. Nothing in writing. Not one thing. It's just gossip. Those are the facts. So there's no evidence. There's nothing. They didn't give me anything which is required, and they just went ahead and did whatever they wanted to do without following the rules and regulations and contractual procedure. And they didn't follow workman's comp rules and regulations. There's no doubt about it because the QME report wasn't finished, and they went ahead and fired me while I was on disability and I had a severe profound hearing impairment. And there was no reason why they sent me home before December 16, 2010 because I wasn't fired on December 7, 2010. And I wasn't disciplined for December 6, 2010 because there's nothing in writing. I didn't receive any registered mail or intent to discharge or suspend. Not one thing. And they had no right taking my lifetime medical away, which they have to replace. I'm asking the judge to have it replaced, court order. So it seems to me that everything has to be a court order. And I guess it's up to Superior Court to close them down because they can't operate without insurance. And if they don't comply, that's cause. All they have to do is show cause. That's all the judge has to do is show cause and cancel their insurance. Safeway Incorporated. So I can show cause that I shouldn't have been sent home. And upon discovery, I'm sure it's going to come out the fact that yes, I wasn't notified or intent to discharge or suspend. Nothing in writing. Just false accusations and nothing to back it up. And I would assume that the union attorney made a mistake because he acted without cause, without justification, without no evidence, within the time limits, within contractual procedure. The union attorney, it's not for me to say, but that'll be for the judge to say. So, and the fact that Mike Nicewonger didn't complete the final hearing, that's another one that the judge will have to take into account under the Disability Act of 2009. Because the unions or anyone else are not allowed to discriminate against the people with hearing impairment. And so, the union is protected, but not under the Disability Act of 2009. So the union is not taking any step to get me back to work, and they have nothing in writing or statements within the time limits of why or who, what, where, and when. And then they had the right to send me home even though the QME report was not complete. And I gave them a copy of the severe profound hearing impairment to complete the QME report, and they didn't take it serious. They just didn't do anything. And they didn't do nothing within the time limits, and they didn't produce any evidence by December 25th, 2010, within 10 days. From December 17th to December 25th, I should say they gave him till the 25th, but they didn't reply in 10, 20, or 30 days with any evidence or anything of that I'm guilty or what the reason is why they sent me home. Not one document within the time limit. They didn't respond within 30 days. That's what I'm talking about. There's no evidence to show cause. So, where I go rattling on. Oh man, I need to get back to work. So anyway, I'm asking for trial. So I guess that's it. I gotta remember this notation was about the fact that the QME was not complete. And the fact that the QME, the doctor said he doesn't do hearing. So that was Adam Stewart's responsibility to get me a hearing test. To complete the QME report, the fact that it said I had a permanent disability, but I don't do hearing tests. So they had no right to send me home on December 7, 2010. And they didn't show cause or anything else why. And I don't know, they're required to do so under the contract. But I don't know, I don't know state law completely. So that's why we need to go to trial to decide if I'm guilty or innocent, and if they discriminated against me underneath the Disability Act of 2009 for the hearing impaired. So I gotta remind myself before I go to court, and I'm waiting for my court date, or a phone call or registered mail. And that's my notation. That's what I come up with. I guess I had a nightmare last night, huh?
Well, I'd like to mention one thing to the Administrative Judge Grill Settlement Conference in Stockton, California. The fact that Mike Sadler assumed that I was guilty. He didn't even have a statement from the dispatcher. I know I'm repeating myself, but the fact is, he asked for my seniority. He took the sole responsibility of sending me home without any evidence or anything else. Okay? And I told him I didn't know what he was talking about. I don't understand what you're talking about. And, you know what? I must have been on disability. Maybe I was on disability. I don't know. It's been such a long time now already. But the fact is, he shouldn't have played judge. He should have had an investigation. He should have found out if I was guilty or not, you know, because there's 2 time clocks there, you know. And the second time clock, I haven't been paid in the last 10 years. And I work 14 hours a day, and I get a trip sheet. I get paid by the mile, me and 400 other truck drivers. We haven't been paid in years by that second time clock. Okay, if we run out of hours or miles down there in Livermore or something like that, we got to drive a truck back and clock out on that second time clock. We're not getting paid by the hour. Now he assumes that he can do that, and he does that, and then right after I have interrogation by the dispatcher, and I have no representation, and he's making false accusation and doesn't make me aware of what he did on December 6, 2010. He did not make me aware that he altered or falsified my logs, and he's not supposed to do that. But he took it upon himself to do it. Okay, that was fine. He told me to sit down. The shop steward's on his way. And then as soon as the shop steward gets there, I go right into Max Sadler's office, and dispatcher hasn't even wrote up the investigative report or anything else. Mike Sadler didn't have anything in his hand. Only thing he had, I guess he wanted me to sign something, but I'm not signing anything because it's not true. I don't know what he's talking about. Okay? So, and then he asked for my seniority, and I don't even know what that's about. So they sent me home with nothing in writing. They violated the contract, work first, grieve later, and I should get paid 14 hours a day, like 400 other truck drivers. They get paid 14 hours a day. I should get paid by the hour. 14 hours a day, just like everybody else. Now, why we have 2 time clocks and the other employees, the 1,000 employees, only have 1 time clock, I don't know. but I haven't been paid in the last 10 years by that second time clock. So that's for the judge to decide what my back pay should be at 14 hours a day. So, and I like Judge Rill to consider the fact that a double standard is the application of different sets of principles for a similar situation or two different people in the same situation. A double standard may take the form of an instance in which certain concepts, often, for example, a word, phrase, social norm, or rule, are perceived as acceptable to be applied by one group of people, but are considered unacceptable, taboo, when applied by another group. The concept of double standards has long been applied, as early as 1872, to different moral structure on men versus women. A double standard, thus, can be described as a sort of bias, morality, unfair suspension towards a certain group of the principle that all are equal in their freedoms. Such double standards are seen as unjustified because they violate a basic maxim of modern legal jurisprudence, that all parties should stand equal before the law. Double standards also violate the principle of justice, known as impartiality, which is based on the assumption that the same standard should be applied to all people, without regard to subjective bias or favoritism, based on social class, rank, ethnicity, gender, religion, sexual orientation, age, or other distinctions. A double standard violates this principle by holding different people accountable according to different standards. The phrase "life is not fair" may be invoked in order to mollify concerns over double standards. I, Julio Zamora, invoke double standards. Life is not fair, and I hope that Judge Rill considers this, sending this case to trial in the interest of justice.